When you make an offer to buy a home and the seller accepts it, you now have a legal contract, meaning that if you backed out, this can cause damages and you can be sued. But there are a few ways to protect yourself. First thing is to have contingencies. These are basically clauses within the contract that say if something goes wrong, you can back out of the deal and get your deposit back. So number one, we have an inspection contingency. This allows you to back out by a certain date if there are repairs needed that the seller won't fix or credit you for. In this case, you get your earnest money back. Number two is appraisal contingency. This states that if the value becomes below the purchase price and the seller does not drop their price down, you can get your earnest money back and back out of the contract. The third one is a little tougher as it only works in certain markets. It's called a home sale contingency. It's used when a buyer wants to make an offer on a new property but is dependent on selling their current home first. The contingency allows the buyer to back out of the purchase contract if they're unable to sell their existing home within a certain period of time. Now, in a competitive seller's market, this will not work if inventory is tight and demand is high. In a buyer's market, on the other hand, the seller has less negotiation power and will be more willing to grant this. Another thing to make sure is that there is a clause in the contract that states if you back out for any reason, your sole remedy will be your initial deposit, meaning you have no further legal liability beyond that. Please share and follow for more home buying tips.